today we're discussing the result in the case of Jordan Peterson and the College of Psychologists of Ontario. The college is the regulator for clinical psychologists, and they ordered Dr. Peterson to complete an education program to address what they called issues regarding professionalism in public statements. This all arose out of some statements Dr. Peterson had made on social media about a variety of issues, from climate change to gender ideology to partisan politics. Dr. Peterson has challenged that order, calling it re-education, saying that the regulator does not have authority to police his speech unrelated to the practice of psychology. He also pointed out that the college investigated these statements because of complaints made by members of the public, not because there had been any complaints made by his patients or even by the people he was tweeting about. Well, the result of the Dr. Peterson legal challenge is in. The order for re-education stands. Here today to discuss this result are two experts, Joanna Baron of the Canadian Constitution Foundation, the charity that I work for, and George Avraam, who represented the CCF in the intervention in the Dr. Peterson matter. Thank you both so much for joining me today. Joanna, at the top, obviously this is a very disappointing result for us, I'm sure for Dr. Peterson as well. Do you know if there are any plans from Dr. Peterson to seek leave to appeal?
So understanding is that, yes, he has publicly announced that he intends to seek leave to appeal. And I'd also add that the CCF, we will also seek leave to intervene at the Ontario Court of Appeal level.
If he's granted leave, right? Now, George, let's talk about the decision itself. The court dismissed the judicial review, and they found that the order for retraining for Dr. Peterson was reasonable. At a very high level, why did they find this?
Yeah, no, thanks, Christine, and thanks for having me. I mean, I think the fundamental issue here is what we lawyers and administrative law junkies deal with, which is the standard of review. And the standard of review is, was this decision reasonable? Not, the question isn't whether it's correct or not. It's whether it's reasonable. And what they found, based on, candidly, a line of case law that most of the administrative and constitutional bar are still scratching their heads over, called Dore and Loyola, about how you balance charter rights against statute regulators' objectives. They found it reasonable, right? So what they said is the public comments he made, even though they weren't complainants in the normal course, his patients, rose to the level that it could, and let me underscore, could cause harm to the public, and therefore the inquiries, complaints, and reports committee issued what they call a remedial order, not a disciplinary order, ordering this training or retraining. And that was really the crux of it. The other key part is that Dr. Peterson, his defense, when they were dealing with the judicial review, really said, look, this is nothing to do with my practice. This has got nothing to do with my clinical psychologist practice. I think the college took a slightly different view, because he said, as a public figure, and this is where I think there's a distinction, he is helping people out there with his commentary, and in a broad sense, he's acting as a clinical psychologist. So the court took that statement and said, Dr. Peterson, you can't have it both ways.
Yeah, that really stood out to me. There's a lot to dig into there. A few things I'm going to follow up on later in the program. The notion of whether or not this was actually discipline, this idea of Dr. Peterson having a broad practice in the public, and the other thing is the notion that there can be this administrative action in response to hypothetical and unproven harm. We're going to get into some of those issues later, but Joanna, in the remaining minute we have here in this segment, what's your high-level reaction to the decision?
Yeah, so echoing what George said, there was a tremendous amount of deference shown. And I think part of the problem is this line of administrative case law that George referenced, Dore. But I also think that it was a convenient amount of deference, and there was really not even a facial attempt, because of course there is in Dore still an indication that you do have to recognize where a charter right is engaged, which nobody disputed, that the right to freedom, that Dr. Peterson's right to freedom of expression was engaged. There needs to be some recognition of that by the regulator. And here there was a one-line throwaway I also found it interesting that
Right.
one of the facts that I found interesting in this case was that there was a precedent, and that was not dealt with in a very convincing way.
Oh, a really important one. Let's discuss this after the break.